Thank you. Let me check the volume on this. Thank you. First, let me introduce myself. My name is Mahon. For those of you who do not know me, I'm the Chief Judge here in the 4th Judicial Circuit. First, let me welcome you. A lot of you, I know this is probably your first visit to the courthouse and maybe to the jury assembly room. I am so happy to have y'all, and I'm so happy you're here not protesting on being able to photograph in the courthouse. It's a happier day for me to have y'all here. This is a very serious issue, and I think it's shown by the number of people that have come and shown an interest. We have a great deal of time and energy has been put in to trying to help explain where we are and where the past has brought us to this point, where we are now and where we're heading. I have some friends that came from other parts of the state to help with this issue. And I know Hank Cox has been instrumental in that. In a second, I'm going to turn it over to him, and he'll introduce the group. But I just wanted, as host and as chief here, to welcome everybody and thank you for your attendance and your attention. We will try to get you in and out as fast as we possibly can with as much information as we can, so you understand this important issue. And there are a lot of things that you really need to know as we go forward in this age of technology. So without any further ado, I'm going to call on Hank and let him take over.
Thank you, Your Honor. I'm up here by default on the night of July 2nd when Mr. Fussell decided to tell his people to push the button and change everything. I learned about it on July 3rd, and David Barksdale and I became active in it. By Monday, Chief Judge Mahon called me and said that Ronnie Fussell wanted to meet with me as long as I would make a commitment that I wouldn't sue him. And I did. I said, I do want to meet with him very much and get this problem solved. I'll get somebody else to sue him. Also, Chief Judge Mahon did want you to know that there's another administrative order that was entered this morning that in the next 45 minutes you cannot criticize him during this meeting, but you can criticize Mr. Fussell. So, just to put numbers in perspective, the number of people in this room is, I think, a reflection of the reliance that people have developed upon access to judicial records electronically. It really is. And there is a school of thought that in Duval County, unlike other parts of the state, we have been spoiled for the last 4.5 years. Whether that's true or not, we'll learn about over the next 90 minutes. There are, if you look around the room, you may not realize that 40 lawyers short of 4,000 lawyers in Duval County. So if you take that number of lawyers and the number of support staff and court reporters, paralegals, legal assistants, etc., you could understand not only why this room is so crowded, but how dependent everybody has become on it. Since the button was pushed the night of July 2nd, the clerk has received 25,119 different requests to look at files, covering 149,000 pages. So there is a great interest in accessing those records electronically. I want to thank, just very briefly, the Jacksonville Bar. There's a little piece of paper, I think, on your chairs. They asked me to ask you to fill it out so they can actually have a record of who came. I also want to thank Holland & Knight, Ackerman Centerfit, McGuire Woods, and Rogers Towers for their assistance in all of this. Judge Mahon mentioned that we have two special guests from out of town here who are going to address you briefly. One is the Honorable Lisa Munyon, who's a circuit judge in the 9th Circuit. Judge Munyon is chair of the Florida Supreme Court's Technology Commission, the Florida Court's Technology Commission, which is I call it the mothership of everything that's happened in the state of Florida by way of the Supreme Court. And also the Honorable Robert Roundtree, the Chief Judge of the 9th Circuit, who is the incoming chair of the Trial Court Budget Committee and the person or the committee that holds a lot of the purse strings that are affecting this. As we sit here right now, or let me back up, as of 4 o'clock yesterday afternoon, people who now learned to make views upon request, request upon views, I'm still learning myself, and you wait for days to get the response, which was not the way it was. You used to get it instantly. You could open up the document, you could print it, you had it, you could access somebody else's case. You didn't have to be attorney of record in that case. There are now approximately 4,300 requests yet to be fulfilled or filled in this county submitted to the clerk. There are approximately 28,000 pages yet to be filled. So you're waiting and waiting. And one of the questions here is this going to stop? Are we now in a process that's going to change how we deal and how we access the information. And there are a lot of people sitting here who go, I don't need that information anymore. I needed it when I asked for it, but now 4 days has passed, 6 days has passed. It doesn't do me any good anymore. And so, no, we're not here. We're here to learn. That's not a criticism. No, I'm serious. All right, before I sit down, I want to say something. What's happened in Duval County, and this is absolutely clear, is not Ronnie Fussell or his office's fault. This is a mandate from the Florida Supreme Court where they were required to submit an application as to how they would implement the mandate. They were given 120 days to implement it, and the 120th day happened to be July 2nd, coincidentally. It is not their fault. What we're here to do today is not criticize or change the world. It is to learn how it happened, why it happened, and how to make it better. We're here to make it better. There are a lot of ways it can improve. And there are a lot of questions that Crystal Watson, his right hand, intends to answer. And you need to go into that with that understanding to appreciate what the Supreme Court has done and mandated to protect the confidentiality of records. That's why we're here. So with that in mind, and I really do encourage people to keep that thought in mind. We're not here because Ronnie Fussell decided he wanted to mess you people up. That's not why we're here at all. He decided he was going to implement what the Florida Supreme Court said he had to implement. So let me begin to ask Judge Munyon to come up here. This process, I think she'll tell you, began in 2003. That culminating why we're here today. So Judge Munyon, if you could come up from the Ninth Circuit, and I'll turn it over to you, and then Judge Roundtree. Oh, I'm sorry, Ronnie. Be nice. I met with.
Thank you, Hank. Can everybody hear me? Great. Glad that you're here. Glad that we're going to bring some clarity to some of these issues. And when Hank said that I decided to make that pull, I didn't decide to make that pull. As he told you, this is something that's been in the works for over 10 years, according to the research I've done. And back in March, when the Supreme Court issued, if you might know, the original order was 0749 was the Supreme Court's order. As you know, 07 is the year. The next one that was dictated was 1419. So there was a 7-year span that information and input was received to the Supreme Court and the Florida Courts Technology Commission before they told us to move forward. We were told to make an application. We made application. We were first told that that application might not be accepted until a later date, but it was accepted earlier, like I think it was 59 or 60 counties. And at that time, we were given a 120-day implement to this 90-day trial period we're in. And we are here to let you know our capabilities are to try to make the process as user-friendly as possible. We do not set the levels of access. That is set by the new one, which is AOSC 1518. That is the last administrative order that is correct, that is out. We've provided you, and I thank Hank's office, I thank Crystal, my whole staff, provided you with, I believe, a copy of 1419 and 1518, and also a copy of the color matrix, because it will be up on the boards, but it's going to be a little hard to see. So we've provided you a color copy of that. And just keep in mind that in this process was something that wasn't funded, and this is what Judge Roundtree can speak to. This wasn't something that was funded. So it's taken a lot of resources to get to this point. It'll take a lot of resources to get past this initial stage, and we will get through it, just like with e-filing. That was another one that was mandated back a year and a half ago. E-filing in the beginning, there were a few thousand that used it. Now we average 40,000 a month. That's the change. Change isn't always bad, and that's what we're here to help you work forward, to understand it, to help you with the process, to let you know what we can do, what we can't do, and we're going to follow the law. I wasn't sure when Hank and Chief Judge Mahon called me and asked me about helping put a meeting together of a few of Hank's closest friends. I wasn't really sure if they made a bet of how many lawyers they could get in this room together, or I wasn't sure, knowing Hank and his competitiveness and Mark, they might have put under one of y'all's chairs one free unlimited access to CORE for a year, so don't be looking at your chair. but it's not there. But I do thank you for being here. I want to thank my staff. The IT staff has worked hard. All of those that have been involved in the process. And my job today is, and my staff's job today is to listen, to facilitate. We're not here to point fingers, to judge anyone. We're here to follow the law. We're here to explain the law to you, and that's why we are so thankful that Judge Munyon and Judge Roundtree are here. Judge Munyon has been in this process for a while. She is the lady that is the chair of the Florida Courts Technology Commission and the Access Governance, where the issues will be addressed. We're going to take one-off questions. Our staff will be here in the end to help you. So hold all your questions, please, until the very end. After the judges are through and Crystal is through, hopefully that'll answer your questions. If it doesn't, the staff will hang around as long as it takes to help you answer any questions. But I'm very thankful for you being here today, and I want to introduce to you at this time Judge Lisa Munyon from the Ninth Circuit, also the chair of the FCTC. Thank you, Judge.
Thank you. Welcome, folks. One thing that I have learned is that apparently when Judge Mahon and Mr. Cox asked me to come and speak with a few of their closest friends, I need to ask more questions. No, but seriously, I do thank you for your interest in this issue, and I just want to give you some history with regard to how we got here. You might think with mandatory e-filing, electronic court records, redaction of confidential information, anonymous public access to court records, that technology has just recently invaded the court system. Well, the Florida Supreme Court has had a technology committee continuously since 1995. And that technology committee eventually morphed into the Florida Courts Technology Commission. Those committees and the commission were established by administrative order until 2010, when the FCTC was codified in Rule 2.236 of the Rules of Judicial Administration. It is composed of 25 members comprised of judges, lawyers, clerks, court administrators, technology officers, and public members. With that very brief background of the FCTC, I want to explain to you how we got where we are today. In 2004, the Florida Supreme Court became concerned that the broad dissemination of court records over the internet could release some very sensitive or confidential information that all of us know is contained within our court records. And because that was on the horizon, the court established the Committee on Privacy and Court Records. It was a committee comprised of legislators, members of the public, lawyers, judges, and it came back in 2005 after a series of public meetings with a report with 24 recommendations. And those recommendations in 2005, many of which were approved by the court, and the court began down a path of altering the procedural rules to limit the confidential information and sensitive information that is contained in court records. You'll know that recently, or not that recently anymore, but you have Rule .420, which is the minimization rule, and Rule 2.425, which is the confidentiality rule. You have to file your notices of confidential information. All of those rules were the result of the work of the Privacy Commission. And it was to lay the groundwork for eventual electronic access to court records. While the implementation of the Privacy Commission's recommendations was in its infancy, some clerks began releasing court records online. And in 2006, the court placed a limited moratorium on clerks releasing court records online. They amended that rule that administrative order in 2007. And with that amended administrative order, lawyers were given general access to records online that were non-confidential. Unfortunately, it appears that That administrative order was not perfectly implemented in some parts of the state. And perhaps lawyers were given access to confidential information in court records without redaction. That redaction should have occurred back in 2006 and 2007 and been ongoing since that time. In placing the limited moratorium on the release of records, the court also established a pilot project for the general release of court records online. It lasted from 2007 to 2011 and was hosted by Chip Shores, the Manatee County Clerk. And it is from his experience that we have the genesis of the access security matrix that you have in front of you, the colored sheet. The access security matrix is not intended to create law. It is simply a compilation of rule and statute. And it will change as rules and statutes change. And it is this access security matrix that gives the clerks a very, as simple as possible, scheme with which to release public records on the internet. I will indicate to you that no clerk is required to release anything on the internet, but if a clerk does release something on the internet, they are required to comply with Florida law and redact confidential information. It's a very complex process, as you can see from that access security matrix. We are a state that has its records in the sunshine, but with those records in the sunshine, there are many exemptions and there are confidentialities. And you will see from that access security matrix that there are many of them that are carved into statute and rule. And the clerks have the very difficult task of implementing and protecting that confidential information. They are not indemnified if they release confidential information to the general public, and the Supreme Court is going to ensure that they have in fact protected confidential information, which is why they have had to make the application and why they have this pilot phase where the court can make sure that they are in fact protecting the information that is required by statute to be protected. Some of that is going to take your patience because it is a complex undertaking. I have absolutely no doubt that the business processes will become such that it will be much more streamlined, but it does take some time to implement a new system and to implement a complex system, which is what our public record scheme has become. So I'm going to ask for your patience with Clerk Fussell while he undergoes this very difficult but important task. And I want you to recognize that perhaps you had access to information to which you might not have been entitled to under the law before he took office, and he is required by the Supreme Court to rectify that situation at this point. I have absolutely no doubt that the matrix will change yearly as the legislature meets and changes the statute, and the clerks will continue to implement those security protocols that are required by the legislature. Again, I want to thank you for your interest. I'm sure there'll be questions after we get finished, but I do hope that you recognize that protecting this confidential information is protecting your clients and is protecting your family. If you don't recognize the very confidential information that's contained in a court file, if you have children that drive, place their name in the clerk system. It'll pop up every ticket that they've had, and some surprising information is contained on those tickets that would be confidential. So this is a very important issue, I believe, to everyone, and I do appreciate your patience. I do believe that Crystal Watson is going to be explaining to you the local process and how they are implementing it, and the systems they're putting in place to make it more efficient, and that will be in just a few moments, but I think Judge Roundtree might have a few words for you.
Thank you. I only want to make one correction that Hank made a mistake, and he usually never makes mistakes. I'm in the 8th Circuit, not the 9th. Judge Munyon is the 9th. The 8th is 6 counties with our major county in Alachua County in Gainesville. I want to talk to you about the magnitude of the issue and the magnitude of the problem that the clerks and the courts are facing with this. Just the size of this group from Duval County or the 4th Circuit ought to impress upon you the magnitude that we're talking about. You've got, what, 700 people that showed up today out of 4,000 that are practicing your law. How many cases do you think just you represent in here that you have of your own? And in those cases, how many pages do you think are in those files? And how much confidential information is in those files? And let me tell you the problem, the issue if something goes wrong. And I'll give you an example that happened in our county. I won't mention in our circuit. I won't mention the county. A parent had a criminal case and a dependency case. And because of a glitch, the Children's Legal Service attorney was able to go into the criminal file and pull up a psychological evaluation that was performed in the criminal file. And then that document was filed without notice to the parent in the dependency file. You can't unring that bell. Yes, you can penalize somebody, you can do something like that. So that's the problem that the clerks are trying to stop. And as Judge Munyon said, the clerks aren't indemnified if they make a mistake. And for those of you that practice personal injury law, if one of your clients' personal information is divulged by mistake, on purpose, it doesn't matter to you. Who are you going to sue? You're going to sue everybody. The person that filed it, the person that didn't file the notice of confidentiality, the clerk, and everybody else. And for those of us that have done personal injury law, you just let them fight their way out of it. And you take the last person standing. So that's what we're trying to stop. The other issue is just the magnitude of the problem statewide. We're now in a 21st, 22nd century technology. I always tell people if you can't see it on here, it doesn't exist. Because this is whatever, all you see is people walking down the hallway, walking down the street, they're looking on here. Well, that's the 22nd or 21st century technology, but we're in an 18th century court system by the Constitution that was established in the 1800s. We have 67 independently elected clerks of court who also serve as the comptroller for their counties. Each of those clerks has the ability to buy, create, whatever system that they wish to use. Duval County uses the core system, and as I understand it, that's a wonderful system. But you have systems like that all over the state. Then you have 20 circuit courts with 20 chief judges. In my circuit, I have to deal with 6 clerks, 4 different clerk systems, and I have to have the ability to try to figure out and navigate through that. So I had somebody ask today, well, why can't I have one password that works statewide? That's why. You have 67 clerks and a bunch of different case systems. So we're trying to wrestle with that backdrop of what we're doing. And then the other issue is funding. I'm chair of the Trial Court Technologies Funding Work Group. Historically, technology has been funded by the counties. And when we did the article revision, where you took to statewide level, the counties were left with technology. Well, back then, technology was a copier and a fax machine. That's all we had. We didn't have networks, and we didn't have electronic access. So the problem for some parts of the state, which you might be able to appreciate in the Fourth Circuit, you've got Duval, then you've got Clay and Nassau. Is there? All right. Different counties, different sizes, different abilities to fund things. In my circuit, we have 6 counties. Some very small, very rural. They don't have the technology capability that Alachua County has or Duval County has. So we're trying to come up with a statewide technology funding issue so we can kind of iron out some of the bumps and seams so that when you want to view something, it's pretty much similar statewide, but that's what we're wrestling with. But Clerk Fussell also has, you heard the numbers. It's easier to prospectively scan something, redact it, if the lawyers have done their job and filed the notice of confidentiality. But he's got how many files go backwards? Thousands? Tens of thousands? Hundreds of thousands? Hundreds of thousands of files that were not filed electronically. They were filed in the old-fashioned day where if you wanted to see a file, you walked down and said, "Can I see file number 32?" A clerk would bring you the file, open it up, and sit there while you look through the file. But now you want to be able to do that electronically. Well, that's fine, but you have to get that paper page to ones and zeros electronically. You do that by taking that and scanning it, then you run it through the redaction software, and then you have to have a set of eyes from the clerk's office review that again to make sure that the software didn't miss something. And we all know that if you have technology, there will be a glitch. There's no doubt about it. And I don't think they've yet got technology that will replace a human brain when you're looking at something. And that's what he's wrestling with. And as Judge Munyon said, this is not something we just cooked up in a room one night and said, let's just turn Jacksonville's access off. You have to comply with the rules and the statutes. And it will get better, I promise you. We went through the same thing in the 8th Circuit. And same hiccups. It's just, you just have a lot more people than we do, and it seems like a much bigger problem. The problem is the same, whether it's here, Gainesville, Miami, Tampa. All the clerks are wrestling with this. All the chief judges are wrestling with this, and nobody's trying to cut your access off. They're just trying to make sure that you see the information legally you're entitled to see, or otherwise you have a mess. Just think about if it's your family and there's something in that file. Do you want everybody in the world to be able to pull that up, even if it was a mistake, and see some confidential information about you, your children, your mother, your sister? That's what he's trying to do. We'll get through it. I appreciate your patience, and I really, really want to impress upon you how impressed I am that this many people from this Bar Association and this circuit showed up. That just shows me how involved you are and how much you care about what's going on. So again, thank you.
My name is Crystal Watson, and I am Mr. Fussell's Chief Administrative Officer. I have talked with some of you in this room through this process from July 3rd until now. For the most part, if you make it up to my level, you've kind of calmed down a little bit and you're not quite as irate as you were with my IT staff. But when there comes understanding, you guys have been incredibly cooperative. You understand, you do what we're asking. We're doing as much as we can through this process. As Judge Munyon described, as Hank described, as Judge Roundtree described, and Ronnie described, this is a very, very, very complex process that we're working on. This, contrary to popular belief, this is not only going into effect in Duval County or in the 4th Circuit. Right now in the 4th Circuit, it is only in effect for the attorneys in Duval County. Fear not, it's coming in Clay in August.
She was trying to hide it.
I know. Clerk Green is joining us in the front corner. But this is going live in Clay County in August. It is going live in Nassau County in October. So it's coming. We just get to be the guinea pig for you. So my IT staff, I kind of have them here in the wings, and they will definitely be answering questions in the end once we get through. I want to go through some points before we actually get to answering your questions. As Clerk Fussell said, our staff will stay as long as you have questions and you want to stay. Hopefully we'll answer a few of those here right now. But I do want to introduce, this is Gerald Cates. He's our IT director. And Gerald and Jill Mishra. Jill is our director over applications and development, and Josh Boone is the man, the myth, the legend. He is the programmer and designer for the entire system of CORE. So We would like to clone Josh and have 2 or 3 more of them. If we had that, the sky's the limit on what we could do. But I want to just tagline a little bit on what Judge Munyon said and give a little bit of history on the Supreme Court's intent for electronic access. If you go back through the AOs back to 2003 that directly speak to public access, it really starts, every one of them start with the importance of the protection of information. That is where the Supreme Court's intent begins and ends, is with that protection of information. After that protection of information, then comes public access. Those two, you can't have one without the other. We can't have public access to electronic records without stringent measures in place to protect the confidential information. Judge Roundtree, the examples that you gave, I know of examples here in Duval County where similar things have happened. I think Clerk Green, I'm sure you could give some examples from your county, and I would guess that every clerk in all 67 counties could say the same thing, that something has been released that should not have been released. And as Judge Munyon said, as Ronnie said, the clerk is not indemnified in that release of information. So it is critically important that we all work together in this process. Right now, Duval County has been, we really have spoiled you guys. And on one hand, we're really sorry. And on the other hand, you had it while you had it. But you had access to information, as Judge Munyon said, that really statutorily never should have been there. And so that was the system that was in place. It was what was inherited by Clerk Fussell, by our staff. And really, we liked it because you guys were really happy. You enjoyed the access that you had. However, what 1419 and subsequently 1518 did was to really rein the access back in to what is allowed statutorily. So if you do not agree with the matrix, if you do not agree with that, you're not agreeing with the statutes or the rules of judicial administration. You can't leave those out as well. Those are critically important. So those two things play hand in hand as we talk about core, as we look at the issues that you guys are having today. I want to talk about a little bit as we look at this implementation. These are really the 5 categories that went into the implementation of core, the transformation from what it was to what it is now, and how that's going to impact across all of the counties. All the 67 counties are looking at these exact same things. So I had some of my staff members do a poll. They called all 67 counties. 34 counties are not providing any records online at all. Okay, so in case you're not good at math, that's about 50%. So 50% of the counties do not provide currently any electronic access to records at all. Okay? Of the 33 that do, it is not all criminal and civil right now. There are several counties that only provide civil, family law, and probate. The largest county in our state, contrary to what has been told to some of you have been told that in Miami-Dade, you can go online and within seconds have an A and B that was just filed. Has anybody heard that? So I see heads shaking. Miami-Dade does not have criminal records online at all. If you want to see an A and B, Clerk Harvey Rubin, Ronnie talked to him this week, he said, if you want to see an A and B in my office, come to the courthouse. If it has been imaged, you can then be able to see it electronically, either on a local drive or on a DVD. That's it. It's not, and I know for some of you, that's acceptable. The A and B is a crucial piece of information in most of your practices. You want to see it to set your fees. You want to see it to decide if you're going to take a case. You want to see it, I heard someone was talking about, I look at the A and B to decide, A, if I want to take a case, if it's with a deadly weapon, what kind of deadly weapon, because it depends on the weapon as to how Angela's office is going to prosecute it. So you look at all of these things, they're crucial. Our office wants to do everything that we can to get you that information, but one of these factors is really, really crucial. So as Judge Roundtree talked about, in his county, there are 4 different software systems. In the 4th Circuit, there are 3. Each county has a different software. What we are working on, well, I should say what we were working on prior to having our application approved in 120 days to implement the changes to 1518. I do want to say, one of the pieces that was made vehemently clear is that if we did not adhere to 1518, to 1419, and then subsequently 1518, if we had not adhered to that, we were instructed that we would have to turn off electronic access immediately. So you either make application or you turn it off, one of the two. So you guys represent, we left it on because that's in the best interest of everyone in this room, it's in the best interest of the public, and is in the best interest of our office as a whole. So software, though, is incredibly important. There's 3 different case management systems. Our office is working with court administration to actually implement CORE in the entire 4th Judicial Circuit. So that CORE would be the software that you would use to access records in Clay, Duval, and Nassau. So, but that project got put on hold because this project, this unfunded mandate, became precedence. We had 120 days to implement it. So that's where the focus went. That's where my IT staff went. The cost to our office was the time that our staff had to put into it, not just our IT staff, but all of those staff that came in and tested to see how it worked, to review the records, to look at, to put this matrix into effect. So, and Josh has done a great job of designing it so that when these legislative updates come, when the matrix changes, it is a minimal impact to change those. Budget is another piece of it, as Judge Roundtree talked about. They're looking at last year's fiscal year 14-15. The budgets approved for Florida, for the counties around Florida, ranged from $282,000. Can you imagine a clerk's office running on $282,000 for a year? That's amazing to me. But it's a small county, I give them that. Versus Miami-Dade that had a budget of $70 million. Okay, now, you have to look at the caseload that Miami-Dade has, and that's why their budgets are substantially higher than Lafayette, which is at $282,000. You also look at staffing. The staffing levels drastically impact how this works. Lafayette has 5 staff members in the clerk's office, 5 that work on courts. 5 staff members. I have 5 staff members, right? That is incredibly impressive. There are over 1,000 statutory obligations for the clerk's office. Those are not the ones that are optional for the clerk's office to do. Over 1,000 statutory obligations for the clerk's office, and they do it with 5 people. Blows my mind. But then Miami-Dade has 1,153. So the staffing levels obviously reflect the caseload as well. In their traffic department alone, there are 850 employees. That's how much traffic they process through there. The application, every county made application based on their interpretation and implementation of 1518. Not every county is going to do it the exact same way. Our Duval County is kind of on the front end of this in terms of how it is being implemented and released. So if you have used it on a daily basis, you have probably seen some changes from day 1 when you requested a VOR to now. It's a substantially different process. On day 1 you came in and you hit request, and did it go through? I'm not really sure. I'm going to say that it did. Some people called the next day and said, I didn't really mean to request anything. Can you remove that? And so we have taken what you've said, we've taken your comments, and we've modified it. I'm going to show you one of the things that is coming very, very soon. But now you get notified by email when things come out, when your redactions are ready, when your VOR is ready to be viewed, you get an email that you can go see it. We've had suggestions on that and definitely taken those into consideration. But the biggest piece is cooperation with all of our judicial partners. And you guys are definitely a big piece of that factor. We talked about, Judge Munyon talked about notice of confidentiality. How many of you in here, okay, and I'm big on participation, so how many of you in here religiously submit your notice of confidentiality? Okay, just kind of look around. That's a very, what's that? Professionally. Okay. So that's a relatively small number. Okay, now then we hear, well, yeah, 90% of what I submit does not have confidential information. What about the 10%? Because the 10% of the documents represented in this room is probably 100,000 pages that my staff has to sit and go through. So, but it's not just the attorneys. It's the attorneys, State's Attorney's Office, PD's office, JSO, the other agencies have to submit these. And again, Duval has done it. The clerk's office in Duval has done a tremendous job for years of doing that redaction because you guys haven't always done it. JSO, we are retraining JSO. You have to submit a notice of confidentiality when you submit your arrest and booking report. You guys know, I know there's some media in here who can definitely pull out probably exactly when it happened. There was a confession that was released in an arrest and booking report. Because on the front page of the A&B, there's a little box that says confession contained. And it wasn't marked. So my staff didn't read for a confession. But there again, do you want an employee who's making $10 an hour deciding between a confession, an admission, and a spontaneous utterance? It's incredibly important that you guys work with us, that those agencies continue to work with us. We have got to get better on getting that information ahead of time. When that comes in, it reduces the time that it takes for us to redact. It reduces the time that it takes for when it's requested to be available. You know, Judge Roundtree was talking about new files. The newer files are going to be available substantially faster than older files are going to be available. We have a warehouse of documents, literally a warehouse of storage that often we have right now. One of the ones that we're redacting is a 3,700-page felony case from 1974. So we had to go and find that in storage, bring it back, image the entire thing, and now redact it. As we talk about, we do run documents through auto redaction software. That's what we've heard from a couple of people. Why don't you just run it through auto redact? Auto redact is only going to catch what you tell it to. So it's going to catch the sequence of social security numbers, probably account numbers. It's going to catch those sequences. But when you come down to victim information. So if the victim is a child and you're reading through a transcript, when the parent's name is included in there, should that also be redacted? Yes, because the rule states that you're supposed to redact everything that can identify the victim, correct? So you can't just let a computer do it. Our office, you have to put human eyes on it. And those things are critically important. They can make or break your case if it gets out. You have to let us know what's there. That's why this is so important. Excuse me. Okay, I want to do an example, a redaction example. Okay, so this is actually one that came out last week, and we got a call about it. This is a petition for stalking injunction. Okay, it was temporarily granted by the courts, and there was an extension granted by the courts. We got a call saying, from an attorney saying, why is my client being hounded by the media? Why are their names released? Why are the children's names released? Show of hands. How many of you in here think that the children's names should be redacted? Show of hands. Okay, almost every hand goes up because your gut says, those are kids' names. They should be redacted, right? Okay, so I immediately call my staff together, get all my leaders, and say, okay, we need to look at the statute, and I want to see it, I want to breathe it, I want to know it, and I want to find it. Yes or no, should it have been redacted? So then we pull up the statute. This is for 2015, okay? The statute for victims of stalking says the names, addresses, telephone numbers of persons who are victims are exempt from 119. Okay, so reading that, if you didn't raise your hand before, you probably would raise your hand now to say the names should have been redacted, correct? Yes? Okay. But then you look to the history. The history of the bill shows that this effective date is actually not until October. The current statute only states that addresses, phone numbers, personal assets are allowed to be redacted, not names. This is a brand new statute that is not even in effect yet. So in this room, of almost everyone in here, you all would have said redact it, right? This is a pretty smart group of people. So, thank you. You would have said redact it, but we would have been wrong. If we would have redacted it ahead of time, we would have been wrong, right? Now, if you got it right, is there anybody in here who got that right? I know there's one. If you got it right, I really have a job for you down in the VOR queue, processing VOR. It is a civil service job, so it's job security, but it only makes between $10 and $15 an hour. You have those employees, and I am not dismissing my employees. They are incredible and do their job with passion every day to not let information get out. But they're not lawyers. They have not gone to law school. This is not what they have been trained to do through education, through experience, et cetera. Their experience is when they come here to this office. That's a heck of a on-the-job training, right? So we need you guys to be doing that. If we take away anything today, please file notice of confidentiality. Just as reference, this is per Rules of Judicial Administration 2.420, and these are the 22 items that are required by the clerk's office to redact. Now, there's argument among the legal community as to whether the clerk's office is required to redact everything in statute, or if we are required to redact only the 22 items in 2420. And there's legal argument. You could argue both sides of it. But our office takes every effort that we can to redact everything, including statutes. If you don't know these items, please go and look at them. Again, Rules of Judicial Administration 2420. But as you look through and see, there are a tremendous amount of information just collected in this 2420. Okay? All right, one of the things I talked about is some of the changes that we're making to core. I want to answer a couple of your questions that you have kind of up front before we move forward. So, a couple of questions right off the cuff. Number one, do you have to re-register as a user? You're already a user. Do you have to re-register? Yes. There have been new registration forms that were put out by the task force for 1419, 1518. They are statewide forms. They are going to be used by, they should be used by every county in the state. They're very simplistic, but yes, you must re-register. Okay? Is that going to give you the access level that you had before? No. However, if you do not fill it out after your, I believe it is, and Gerald, you can correct me, after you log in, you have 60 days, after you log in the first time in core, after this change, you have 60 days to fill out and resubmit that form, or you're going to lose your access. So again, do you have to fill out the form? Yes. Okay? There are some new features in core that were not necessarily there before. Some were, some are not being implemented entirely in your offices. Your office can have a gatekeeper. So state's attorney's office has a different level of access than just a attorney of record. So the state's attorney's office has a gatekeeper. Their gatekeeper is responsible for granting access at the state attorney level. So if you are an employee of the state attorney's office and you are here, I've talked to several of you, that you're not getting the access that you should have, well, you need to contact your gatekeeper and ensure that you have been granted the proper level of access. Okay? Lots of questions have come in. I am the attorney of record, but I don't have access to my case. Okay, usually that is because you're not associated with the case. We just need to go in and make that association. If you call the department that you work with every day, they will make that association for you. It can be as simple as John Smith, there might be 5 John Smiths and the wrong John Smith has been selected. So that needs to be corrected. What we are doing, are you John Smith? Nope. But we are also making the effort to connect your bar number to your cases. So that is how it, if your bar number was connected to your cases before, you should have still maintained your attorney of record access, okay? If you're having an issue with that, please let our office know. I'm going to have an email address that we set up specifically for attorneys to contact us in regards to those issues. But some of the other issues that we've seen are in pertaining to the VOR. So we've modified, this is a screen that you're going to get. We got asked recently, can you include, because now you get an email that says, these documents are available. These case numbers, this is the docket type. But someone asked, can you please put party information in there? Sometimes I have 40 or 50 documents that I've requested, and I don't really know unless I go into the case number what it is. Can you just give us the party name so it jogs our memory? However, there are rules about some party names are confidential and not allowed to be released. So then if we release that in an email, and now it's out in the public domain for public records request, what do you do with that? So we're not including party names in emails because of confidential information. However, what we're doing is you will have now under your account, you will have my VOR requests, and it will show the request number, which you should have gotten whenever you submitted it, when it was requested and completed, the case number, both party names, line number that was requested, and the docket text, okay? And then it'll also show if it's pending or ready to view. If it's ready to view, you click on that link and it pulls it up right there. You don't have to go back into the case and find it. So that's based on information that we've heard from you, complaints we've heard from you, suggestions we've heard from you. We're trying to make it better every day. One of the things I asked Gerald as we were waiting is, because we definitely heard a spontaneous utterance when they ask, okay, we requested it 4 days ago and I don't need it anymore. Okay, will you be able to go in and say, I don't need this anymore, and pull that out of the queue? Yes, that is going to be an option. Okay, how tremendous is that? If you go in and say, I don't need this anymore, it pulls it out of the queue, so now the next document is available. So now we're really redacting the documents that are need to be available that you really need to see. Okay? We're not asking questions yet. Wait till the end, okay? He's antsy, he's on it. So we're looking at these changes, we are trying to make these changes. There's one thing I do want to point out on VOR. Okay, so viewable on request, really, I think you probably have gotten this. Viewable on request really are those documents that contain confidential information that we just need to put one more set of eyes on before it goes out to the public, before it goes out and is released from our office. That is the importance of VOR. That is why it is there. It is for that one more look. Through this process, there were some document types that were set as VOR at the beginning. We've turned that off because as we redact through them, as we review them, there is no confidential information in these documents. It is no longer VOR. Okay? We will continue to evaluate that. We are in a 90-day test period. Okay? We're in this test period to look through those things to make modifications to the system. And that's where some of this comes from as well. When a document has been requested as a VOR, it has been reviewed, and it is made available, it no longer needs to be requested again. Okay? So if you request a document as a VOR and someone over here requests that same document next week, it is going to be immediately available to them, whereas you had to wait for the VOR. Obviously, through time, you will have less and less VOR because the documents have been redacted and reviewed. Okay? Make sense? Okay, I want to go through and answer some of the questions that you guys have. This email address is very important. If you have questions as we go forward at the end of this, if you do need to leave and ask some more questions, Core Attorney Help Desk at DuvalClerk.com. Okay, so some of the questions that we've gotten thus far that I just want to go through, these are frequently asked questions that that have come through our office. Just want to look through those really quick. We have had some that are not very happy with our office. If you're here, please don't raise your hand. I don't need to know. How much warning did you receive in advance that this change was going to be put into place, and what, if anything, did you do in preparation? These are the questions that we're getting. These are the questions that my staff are getting. They are getting berated. It's a little less and less. I think you guys are calming down a little bit. But these are questions from last week. Did you communicate with anyone with the Office of State Attorney, Public Defender, or Judicial Administration in regards to this pending change before it was put into place? Nah. Nah. So moving forward past the 6 questions to that end, will we utilize software to review documents for confidential information, and how fast is the process? We do use auto-redact software now. We are continuing to work with the company to make it better, to make it more effective, and to find more of the information readily. However, the examples that we've given before, you cannot take away the human approach to it, because there are some things that auto-redact simply will not grab. You can set it primarily civil. You can do that a lot easier on the civil documents, where you're looking for account numbers, social security numbers, bank numbers, etc. When it comes down to names and information, we again say, if it is your child, your mom, your name, do you want us to just shoot it through auto-redact and release it, or do you want us to look at it? And most everybody is going to say, better not release my kid's name. Okay. Yeah, we'll skip that last one too. I have a potential client coming in this afternoon. If I request an A and B, how long before I can view it? It depends on how many are in front of you. We really are requesting VORs departmentally based on when they come in and the volume of the document. So if it's a 500-page document, 1,000-page document, you're going to get an email back that says this document is rather voluminous. It's going to take a little longer than normal. Here's the deal. On an A and B, when it comes in, if you need it immediately, you're going to have to go back old school, come to the courthouse. Or, here's a novel concept. JSO is the holder of the record. They are the ones who own the record. Go to JSO. But when you come in the courthouse, remember, if you want a copy of it, there's a copy charge. So you can look at it on the kiosk. However, if you need to see it immediately, that's what you're going to have to do. If you request it VOR and it is not available before you need to see it, come to the courthouse. We also had a question from some of the media outlets who do legal publications. They need to verify the information for documents that are being published that day. Come to the courthouse. That is the best advice I can give you if you need to see it absolutely today. Okay, but me saying that, we have to look at the staffing levels that we have, because that is going to increase requests immediately in the courthouse, which will slow down some of the VOR, as well as keeping the balance on the e-filing queue. Like Clerk Fussell said, we have 40,000 e-filing documents coming in per month. We right now have we've been maintaining roughly 5,000 documents in the VOR queue consistently, which from the beginning has been, we've received about 25,000 requests for VOR, which was about 170,000 pages that have been requested and reviewed. Okay, so if you need it immediately, you get to see our smiling faces. Okay, one of the other pieces that we've had lots and lots and lots of questions about is, okay, in my law firm, I'm an attorney who is attorney of record, but my law clerk needs to see this file too. He or she does not have access to that. There's this handy dandy feature called delegation. So under your account, you can delegate access 2, if you have a co-counsel, if you have someone standing in for you in court, if you can't make it that day, if you have a law clerk, you can delegate your access to that person. You are in control of that, okay? The option is not to give someone your access. We know it happens. We've actually had calls, hey, why doesn't this work anymore? That person's not with, we were told that person was not with the law firm anymore. Why are you using their login? Don't use other people's login. Have them delegate the access to you, and then if you delegate access, you can see who you've delegated access to. You need to maintain that. You need to keep up with it, okay? But we are going to put instructions for delegation on the first page of CORE. So where you log into CORE, we're going to put a link to delegation instructions. We were going to go through it in here today. It's a little complicated. It's going to be, there will be written typed instructions on how to delegate access today. Today.
Well, it's available to delegate today.
Right. When can they be available?
You can do it, but you can't know how.
Right. He can get a what?
He says he can get them populated today.
Josh is going to get them populated today. The man, the myth, the legend. Okay. How do we add co-counsel to a criminal case? In criminal cases, you now have the ability, this was a software change that had to be made within our case management system. Previously, you could only have 1 attorney of record on criminal cases. Now you can have up to 10. Correct? 10? Is that accurate, Jill? See, I just spit the information. They have to make it happen.
We made it 25 for a bar number, where you carry a bar number, 25 and 5 for.
Okay, so you can delegate up to 25, and you can who have a bar number, and then only 5 who do not have a bar number. Okay? I know it's just right. It's been 90 minutes now. That's what we promised you. We will stay here and go through some questions. I want to give it back to Judge Mahon. I personally want to thank Judge Munyon for coming. I want to thank all of you for, let me say that first, because you guys, some of you are leaving. Thank you all for coming. Really, understanding is the key to all of this. But Judge Munyon, thank you so much for all the work that you've done, the FCTC has done. We appreciate it. Judge Roundtree, thank you.
And let me say very quickly, because I know you're leaving. I talked with my wife this morning, and I said, I've got a big meeting with the lawyers about CORE. And she's got a background as a legal secretary, and she said, oh, y'all are going to fix it. I said, oh, no. And she said, well, you better not tell them that at the beginning of the meeting, or everybody will be ticked off. You now understand where we are. We were fielding questions. Ronnie was, I was. We were fielding questions piecemeal. I had, at their own expense, Judge Munyon's in Orlando. She got up this morning and drove to Jacksonville. She is the mecca for court technology. She's the one that was there from the beginning and came up out of the goodness of her heart just to answer the questions for the lawyers. And Judge Roundtree, he's the chief in Alachua. He got up this morning and drove from the 8th Circuit from Gainesville just in case y'all had questions. I can't tell you how much that means to me. And y'all's interest in that is just huge. I hope that while you may not be happy with some of the information you had today, you now understand why we are where we are. And if you have questions or issues, or if you have concerns, you can reach out to Judge Munyon and say, I wish the Supreme Court would consider a change in the rule in this. You can reach out to your legislators and say, I wish you would consider some type of change. This is a work in progress, just like the first iteration of any technology is not the last. And so I can't thank these people enough for taking time out of their day, at their own expense, driving up to Jacksonville to be available for y'all. And I want to, myself, want to give them a hand. All right. questions, I guess, at this point.
All right, that's it. Hold on one moment. One of the other things I do want to say is, as we talk about if you have requests for changes that you would like the Supreme Court or the Access Governance Board, FCTC, to make, please send them to, you can send them to our office if you don't want to send them straight to the FCTC. Actually, our office is compiling a list that we will be submitting prior to the next Access Governance Board, which is in the beginning of August, for the one-offs. There are one-off situations that really we don't have an answer to. Regional Conflict Counsel, how are they handled? Court reporters, how are they handled? Court reporters use the dockets, they use the files, they use the documents.
Just hold on 1 second. If everybody's got to leave, let's go ahead and leave them once. Let's let everybody clear. I wanted to be where you could totally ask your questions and we could hear them. All right, everybody's gone that needs to go, and we're here. All right, and we'll turn it back over to Crystal. This lady, is that Leslie? Is that Leslie? Who was first? Who had their hands first?
Well, that gentleman right back there, he's been waving. He's been waving halfway through.
Stand up and pick your question. Remember, you got a little mic.
Oh, okay. First, thank you for doing this. Those of us who have had reason to follow this process since 2006 know what an undertaking it is, and thank you for it. My question is this. Under the rules, there are two ways for an attorney to make an appearance in a case. File a notice of appearance or just file a pleading or some document. Will both of those methods trigger being recorded in the system as an attorney of record so that we would have attorney of record access?
We are working through that method. It's actually that's one of the questions that was in the frequently asked questions that we get. When you file a notice of appearance, that triggers it immediately. We're going to put you directly in there because there are pleadings in cases. There are people who file in cases that are not the attorney of record. Right. Well, we will take care of it for you today. And here, this is another thing. Yes.
There's actually a third way you can come in. That's through a substitution of counsel when you file a motion to substitute counsel. But you're correct. It's file the initial pleading, notice of appearance, or order of substitution of counsel. And those should be the only three ways that you're attorney of record.
Right. Okay, everybody clear on that one? Because we do have actually one of the emails that we got said, I never file notice of appearance on a case. Shouldn't the clerk be able to figure out who's the attorney of record? Okay.
I have a substantive question that's a legal question, and I also have a comment. But the first is, and this is probably best answered by the judges, is public records law doesn't require something to be in writing. And this view on request is only able to be initiated by in writing, which is in direct conflict with the public records request law. What was the analysis that was done on that and how that doesn't violate it? And is there some place where you can read that analysis?
No clerk is required to put anything online, and they are required to have the records at their office where they do their normal business. That is what is required by the statute. So anything that is placed online is done basically at the grace of the clerk. And they are required to protect that confidential information, and they are meeting their obligation by doing the viewable on request.
Yes, but I have a question though, but it's creating a record of having to do a written request, which is then able to be pulled. And under public records request law, there isn't a record kept.
Well, you don't have to request them online. You can go to the courthouse and request them, and then there is no record.
Okay. And my other comment or my comment was, I think what has gotten the legal profession so upset, and I know it has me, is that we've gotten lumped into this group that's the same as the public. We're officers of the court. We have rules that we must abide, and we think that there should be another category that includes attorneys about what we're allowed to see in court records.
All right, no disrespect to you or any individual attorney here, but I think legally, and I think the thought process is if you are not attorney of record in that case, you are the public. Just because you have a bar card does not give you special status to go look at somebody's confidential information. You are the public. If you're not that client's attorney, you're not that party's attorney, how are you any different than the doctor, the neighbor, the reporter, anybody else? You are the public. That's just the legal analysis of that would be. I understand you don't like it, but you have to. We all know people that just because they have a bar card, I'm not leaving my children with them. Why would I leave my confidential records with them? So,
you go ahead. Good morning. I have a question as an attorney on the wheel, particularly juvenile cases. When a judge's office calls and says, can you take this case? I cannot type in a child's name. I have to have a case number. Yet the information on there is redacted. So I don't know if I'm actively representing the victim or a co-defendant. What are we supposed to do in that instance?
Gerald?
Court admin should be able to delegate that authority. That
Okay.
sound reasonable.
You want to say that out loud?
I'm going to check with my staff because they're smarter than I am. Could court admin delegate that authority to them?
Currently.
Not currently?
Like
Okay.
You say the wheel, are you talking about the registry?
Yes.
Right, so you are actually a conflict
Can you take notes?
counsel on the registry.
We'll review it.
I would think there would be some, again, just personally, there would be either some accommodation because the court has placed you on the registry.
And for instance, yesterday I got a call and the judge wanted me to come to court immediately.
Right.
I can't answer the question because I don't know who the co-defendants are.
I understand the problem.
And you haven't gotten your written order yet
Right.
appointing you.
I can accept it. I can't accept it until I can say whether or not I have another conflict or not.
Right. And what we are going to do too, any of the questions we cannot answer right this minute, we are writing those down, and we will post on our website the questions from here that didn't get answered. Okay.
And any of those, there's a lot of one-off questions
Right.
that we will be taking to the FCTC for you, because it's not questions that we can fix or give you an answer to, that we have to take to the commission to get those answers, and we're willing to help do that. And I think there's a large group from the public defenders to others that are going to be coming to the commission to ask those same questions. So just because we can't answer it, and we might not be able to fulfill it anyway statutorily, so we will bring that to them in the
We may have to ask the legislature.
and they may have to ask the legislature. So there are proper questions. So if you don't get your answer today, we will continue to try to get you that answer.
Sorry, he gave me the mic. Okay, this question is for Josh Boone. And when you spoke earlier about making the association to make somebody attorney of record, and the questions that we've already gotten, are there any plans for an algorithm or some sort of code to work with the e-filing system and CORE to automatically make the association? And why or why not?
No. Okay. Go ahead, flip Jill.
Josh question, but say your question again.
Why have we not made an algorithm or a formula for this core system to automatically make people attorney of record and make the association that it sounds like you are manually making right now, linking our bar numbers? Because we file under our bar numbers, we're attorney of record under our bar numbers. Why is there a missing link there?
Well, it depends on the document that's filed, right? That makes you attorney of record. So it's not just every document you filed is not going to automatically make you an attorney of record.
But of course, if I file a notice of appearance under my bar number, Why is CORE not automatically pulling that information?
That's not CORE. It's our case management system assigns the bar number. We are working with our vendor to develop a workflow that will automatically pop up the attorney table and have them type in the bar number. It's not there yet, but we should have it shortly.
And if I'm not mistaken, there are processes in place. There's technology that is being reviewed right now. You know, the question was, why can't I log in one place and have one log on through the entire state? I know that they're working towards that end to try to make that a possibility. Right now, it's not. But they're working towards that. So again, this is very much a pilot, as Judge Roundtree said in the beginning of this is the first phase. And so now we got to work out the kinks, and that's what we're doing. So we're there. I know that there are processes in place working towards that. Part of, the software being updated is definitely going to be key. We've had already multiple requests to our software company. But again, in Duval County, we have one. Clay has another, Nassau has another. So all of those, each county does their own thing. So it's making all 67 constitutional officers do the exact same thing.
Keep in mind, we still had no funding to do anything, so we're shifting resources around to make these things happen for you. This man back here has had his hand up for a while.
Okay.
I'm still not sure about filing a notice of appearance. I had a client come in a couple of weeks ago who been called. I couldn't get access to the case to see how he was served or who accepted service by substitute. So it was the process. So if I had filed a notice of appearance, would I then have been allowed to look at the pleading to see who got served in his stead? And if by doing that, am I in the case at that point? I just want to look at the file to see if I'm going to get involved. That's a real problem.
What was that?
Legally, if you file a notice of appearance, you are in the case until you are allowed to withdraw. So in that type of situation, I guess until it's been redacted, until there's been a view on request, and it's been redacted, because the general public would be able to see that if there was no confidential information in there, as I understand the system. So if you were not allowed to see it? Did you do a view on request?
Oh, I did.
Okay.
I did, and 3 days later, I got to see the return of service.
I understand, but again, that's just, as I talked earlier, the magnitude of the problem. And, it's wonderful that y'all are so large and that you're so engaged and you have so many people involved, but that's also a big problem for the clerk.
So when we register, there's another column here. Individuals registered for subscriber service. If we register under that column, can we look at the file like the DOR without any attorney of record?
If you are not attorney of record or a party, you do not have access to confidential information under the statute and rules.
But what you're looking at is not confidential. It's just a default in a service of process form.
That's where we've gone through and made some documents public now. We've had to go through that process, realizing we've made them on request. Well, yeah, there are some documents that we're currently reviewing and we're making them public, so you don't have to request them. But right now, the clerks locked everything down, and now they're realizing some of these are public. So we're working on that.
We are working through and making changes. That's what I mentioned a little bit earlier. As we're going through, there were almost all of them were VOR in the beginning. If there was a question, make it VOR. Many of those have been changed to just be public access. And we continue to make those changes as we evaluate and ensure that there is no confidential information within that document type. Okay?
So I defend consumer cases, circuit civil cases throughout the entire state of Florida. I represent people from the Panhandle to the Peninsula. And the first thing I have to say is that she's right, that half of the counties in Florida You can't access anything. That's true. But what she didn't say is that this core technology is actually proprietary to Duval. There's not another county in Florida that has it, and as someone who's used everything, there's nothing better than this system. Now we put a throttle on it. That's a whole nother issue. But my concern has to actually deal with the AOSC 1518 itself. And for anybody who hasn't actually read it, read it.
Thank you.
If you look at, on page 3 of the standards for access, it tells you what an attorney of record is supposed to have access to and how that the attorney gets access as attorney of record. If you're not an attorney of record, you are by default, because you have filled out an agreement with a password and the notarization, because you filled it out, by default you're an individual registered, you're a subscriber, you're a subscriber, individual registered for subscriber service. Now what that says that you're supposed to, this is what the AOSC 1518 says. It says that you're supposed to have access to anything unless it is all records except those that are expunged or sealed, automatically confidential under Rule 2.420D1, or made confidential by court order. Right? So that's anything but that. Viewable on request, remote access to images of records in the case governed by Florida Rules of Family Procedure, Florida Rules of Juvenile Procedure, or Florida Probate Rules pursuant to 28.22215A. Florida statutes. What it doesn't say is you are limited to access with circuit civil cases. It doesn't say that you have to view on request circuit civil cases. It doesn't say that you are restricted to access in county court cases. Now, they attach a color-coded matrix. And if you look at the access, if you look at this matrix and just go down to circuit civil and county court, and you look at the level of access, it's a D, which is in the top corner, and it's highlighted in green. It says all but expunged, sealed, confidential, recorded images viewable upon request. Now, what I've argued with the clerk is that's a shorthand. This is a shorthand for what's in here. That's all it is. But the way the clerk's office is, and not just the Duval County clerk, but I guess all the clerks have, they've interpreted it to mean all circuit civil cases, all county cases. Now, for me personally, as someone who represents people who are being sued in these cases, they constantly are coming to me, meeting with me. I give them 45 minutes to talk to me about their case, and I can't see anything. These are defendants in these cases. I ought to be able to, as access to the court, as an attorney, I ought to be able to represent and give counsel to these people. Now, in federal cases, you're required to certify that you've redacted all confidential information. I believe
you are required to do that too. When you e-file, everyone in here, when you e-file, you are required to say, yes, I have redacted all confidential information. There's nothing to redact confidentially. And you're certifying that you've done it. How many just remaining in here? Because we ask this question every single time. How many actually do it, or do you just click the button? Because if you don't pick a button, you can't move forward. There are hands around the room. They are not filing the notice of confidentiality.
Well, I'm not a plaintiff.
And on those,
I'm not here to argue with you. I'm just here to state.
Well, but you're bringing up, you're saying that we're interpreting it incorrectly, which I believe, are you Mr. Parker?
Yeah.
Yes, we've spoke through email, and we did not, and the clerks did not just pull this out of thin air and make this our own interpretation. I believe you've also spoke with Judge Munyon, who's over FCTC, and this isn't just a clerk interpretation. This is from the Supreme Court's delegation to the FCTC and their interpretation. If you can certify to me right now that none of those documents that you are arguing that you should be able to see right this minute have no confidential information in them, if you can guarantee that none of them have any confidential information in them, then we will go flip that VOR switch.
Really? Because I don't think that should be the standard. I don't think you should kill a fly with a cannonball. And what you're doing is, by interpreting it this way, you're denying access to the court in a way that pits the rights of defendants against the right to privacy, and there's a problem. But
okay, I don't think there's going to be a resolution right here.
It's not.
And so on the first weekend, on the first week of August, the FCTC is having a meeting, and if you would like to go and argue that with FCTC and the Access Governance Board, I'm sure they would be happy to take that up, but it's not going to be resolved here in Duval County. It's not going to be resolved at this meeting because our interpretation is not from us. We are being delegated, we are being dictated and prescribed this information with interpretation from a statewide committee, not just our office of 350 people. So we're not going to resolve this today. Our interpretation is this, and that is what has been implemented as has been dictated from the FCTC. This lady's had her hand up for quite a while.
Okay, 2 questions. Number 1, is the delegation tool actually working? Because I got an email from the core help desk yesterday saying, I mean, he gave me
instructions on how to delegate. It's working today.
Okay,
Josh
so
fixed it last night.
It's actually working.
Yeah,
okay.
Josh fixed it last night.
Second question, we're with Jacksonville Area Legal Aid, and so we help about 10,000 people plus a year.
You're one of the one-offs that we're looking for access.
Is there a way that you can like request to see a file in total, so that way, you know, the clerk can just review one file for all the documents? Because we're dead in the water as far as trying to give individual advice and trying to evaluate the case until we can see these documents, and our people are having the same problems. They're requesting them. I'm sure we're probably backlogging you quite a bit, I'm sure. Right. But we're having 2-week delays and people are missing deadlines. So
well, and that's where, you know, and I hate that I am saying this answer, but come to the courthouse and sit at the kiosk and look at the file immediately. I mean, and we will have to sit and do the redaction right there and push the documents to you right at that moment.
So now, are we going to like the individual area clerks, or are we just going to go to court records? Like, where should we be sending our staff?
Probably where the clerk's office where that file is kept.
Well, I mean, because it's going to be probably 15 different areas. So
again, you know, don't shoot the messenger. As she mentioned earlier, there are 34 clerks of court that provide nothing online, which they're not required to do. And if you want to see it, you do it the old-fashioned way. And so you would walk down, you'd flip through the file, there would be a clerk sitting there watching you, and hopefully all the information had been redacted. They're trying to provide you a service, and by what I've heard, I've not viewed the core system, it's probably the best in the state. So it's going to take a while to get all of these files redacted. Once that file has been redacted, it is online. You don't have to request it again, as she said earlier. So it's like eating the elephant one bite at a time. It's going to take some time. And I know it's frustrating. It's frustrating for me when I have some judges that don't know how to turn on a computer, and we're now totally electronic. And we don't have paper files. And we're trying to bring them into the age. So I know it's frustrating.
I know this lady has had her hand up since almost the beginning. Green shirt.
Well, I had two questions, but if the delegation issue's been fixed, great, because the little box never showed up to enter the person. The second one is with co-counsel. We frequently have cases where our attorney is co-counsel, but the complaint was filed by the other attorney, the out-of-firm attorney, and CORE, now that they've flipped the switch, only picks up the name of the other attorney, even though our attorney's name is on the complaint. We do not have access because we are not the official attorney of record. They only show our co-counsel, who actually, Circuit Civil. I mean, and this is going to happen a lot where the other firm files a complaint. Our attorney's name is in the signature block. It's on the e-service tab for the e-filing portal, but we don't have access through CORE because we are not the official attorney of record.
Would filing a notice of co-counsel solve it?
I mean, the name is on the complaint. It should be picked up.
I get that, but this is electronic. Again, it's like the redaction software. if you expect, and I don't know how complex your cases are, but if you file a 37-page complaint and you're expecting the core system to read through that complaint and pull out another attorney's name, why don't you just file a notice of co-counsel?
No, but I mean, the other attorney will put in our names with the original filing.
That's e-filing.
I know, but...
And that's one of the things, is it's not the same, and we're working.
They can't, I think somebody mentioned it up too, electronically linking to the e-filing. I know.
That is owned by the state.
So how do we as co-counsel get into the core system as attorney of record when our name is on the complaint?
Regarding the portal, I'm actually on the e-filing board. The first thing we're trying to accomplish with the portal is the standardization across the state. So for example, I don't know if you guys are starting to notice, for the Fourth Circuit, when you go in and you pick a case type or a subcase type, you should be seeing more common, if not the same, excuse me, choices. So that's the first challenge that we're getting through with the portal. We were put back a little bit with the clerk's offices with limited resources. Sorry, with limited resources because of trying to meet this AO 1518. So that got pushed out just a little bit, but standardization on the portal is a priority. And then second to that would be trying to figure out, when you sign through the portal, make that link. I think somebody talked about algorithms. Make that link into the individual case management system. So I'm taking notes on that. It has been discussed over the last year, but there has been a delay just with all the different technology initiatives coming through.
So how do you want to answer the question? Do we just email or attorney help desk and say, add my name?
Can you file notice of co-counsel?
I suppose so, but it's kind of redundant.
But that is an effective way to do it. That is, you file a notice of co-counsel and... Okay, I'm sorry that you don't like the answer. Not everyone likes the answers.
I have several. Madam, since you're here, is there going to be an option to actually name the pleading that you're filing as opposed to the generic names that are listed on the e-portal? Because I'm asked, there's nothing worse than having to say motion for something when it's not even close to what I'm actually filing.
Are you asking on behalf of the Fourth Circuit?
I'm asking on behalf of the state.
So here's where it gets interesting. As you look at the way different things are filed in all the counties by different attorneys and the way things are called, it's negotiating across the state how we get a standardization of what we want to call these things. So no matter what county you go to, you know that a return of service is a return of service, and it's not called 4 or 5 other different things, and you're trying to guess which one to choose. So there's some compromise and negotiating in the standardization. I will tell you that the clerk's offices, when they receive those filings through the portal and they go to docket, that's when they can add a level of detail. So if that detail's there, they can add it on the docket line so the judges can see it, so the attorneys can see it. That level of detail can be added a second layer. The standardization is quite an undertaking, trying to get that across the entire state so that no matter where you are, what county you're in, if you're in Tampa filing up in Duval, you know that whatever you choose is the right thing that you choose. So it's a higher, more general level.
Okay.
So it answers the level of detail.
Thank you. Okay, going to this. Where is the form? How soon do we need to file the form that you're requiring us to file? Since we
60 days.
Okay, where is that form, ma'am?
That form is
at
the home when you go onto CORE.
Okay.
Yeah, click on Welcome on CORE.
Okay.
Let's see, we got to share this right now.
Sorry.
The registration forms are when you go to log into CORE, there's a little over to the left, there's welcome. All of the agreements are right there.
Okay. Do we need to file a different form for each of the 3 counties in the 4th Judicial Circuit?
Yes, you will. All 3 counties are different. Again, they all have different systems, and each clerk has to have an agreement with you. You're not filing an agreement with court administration for the 4th Judicial Circuit. You're signing an agreement with each individual clerk's office for that information. Now we don't have to share.
Great. As to older cases, cases where you would go and they would be in the OR book and page that say because of the Chapter 119, will we be ever be able to get those older files, those older final judgments, or will we still have to come down to the courthouse to get them?
In the official records prior to 1980?
Yes, ma'am. Or not, well, even whatever we used to be able to get when you go to the OR book and page.
Well, the official records is different. That's actually an Encore, which is a different program than Core altogether. And that one actually was made public access many moons ago. And so you do not have to have a login to go into Encore if you know the booking page, go into Encore.
But they're taken off. They're gone. When you go to an old final judgment of marriage, for example,
then it may not have been imaged in there.
The image used to be there, but it's gone now.
Well, if you will email an example of that, we'll look into it.
Okay. This is now up and running. This right here, this help desk.
Email address?
The help desk.
The help desk has been in place since Core began.
Okay.
This is an email particularly for attorneys.
Okay. Would it be possible for there to be a dedicated line, and I know your budget is stretched, and I do very much appreciate the opportunity for this, because as a sole practitioner with no secretary, it's very difficult to get things done now. And would it be possible to have a dedicated line for the human being to help attorneys with these issues?
There is a Core help desk line. Do you know that number offhand? I don't ever call it, I just call her extension. But there is a dedicated Core help desk line, and before you walk out of this room, I will give it to you. I will say that approximately 80% of the calls that come in are from attorneys, so it is almost a dedicated attorney help desk line. We are, this is there just as one extra layer for you, that we will answer those before just the general public, because we know you guys are keeping the wheels of justice moving. This is your livelihood. We are trying to make it as easy as we possibly can.
Okay, last question. I do adoptions on occasion.
Okay.
And I don't even think I can pull up dockets anymore.
No, you cannot.
So I can't even tell someone if they call me and say, oh, well, I think this person's rights were terminated, so that I can go forward with an adoption. Is there anything I can't even begin to help them?
Not online, you cannot.
So I have to come to the courthouse. I have no choice. Okay. Thank you for your help.
Yes, ma'am. Do you have that number? He's working on it.
It's on the registration form.
Crystal.
I see you.
I think I speak for most of the people in the room, is that, we were all surprised when literally every document, was on VOR. And you made a comment that your clerks realized that they had made a mistake in being overly zealous in doing VOR.
I didn't say we made a mistake. I don't think it was a mistake.
Okay. But anyway, you said that they're in the process of trying to go through and, make those documents more readily available. How is that process being done, and how soon do you think that, just normal everyday documents that we would file on a daily basis that would have no reason for redaction are going to be available at all times?
Through this, we have a 90-day test period that we're going through right now. It's a pilot period. And through that pilot period, we are taking the time, we are evaluating. So my staff that are you waiting to answer that question? Or you? Okay. So the staff that is reviewing and actually redacting these documents, they're some of our supervisors that are looking at those to give the proper feedback to say this document type does not ever have any confidential information on it. We do not need to make this VOR, so it's been removed. That's a constant process that we're doing. So when that happens, all of those become public. It is, if you had requested it as VOR and we make that change, it becomes public and it's now available to you. Okay, so it's a process that we're working through. So again, when we can certify that this document type, and it's broken down by document type, if this document type never has any confidential information on it, it can be public. It can just be public access. If there is a possibility that there's confidential information filed in that document, our office has to make every due diligent effort that we can to protect that information. And again, looking at just the 22 that are in 2420, not breaking down into statute level, just those 22 in 2420, it cover a lot of records, okay? He's had his hand up again for a while. You shouldn't get a second question yet till everybody gets there first.
Well, wait a minute. Thank you. Now, I don't mean to suggest this is the clerk's obligation, but what process is in place across the whole system when a filer, a user, files a document that contains confidential information but does not file a notice or a motion or otherwise comply with 2420? Does the clerk's office have a process for notifying the filer? Or, I mean, because if the state attorney, just to use an example, files an arrest and booking report with a confession in it, and it becomes public, you know, what's the procedure to stop that or penalize?
Well, the procedure to stop that is that the clerk reviews it before it is released. And I would love if...
I can tell you about the statewide efforts that have been discussed. The FCTC saw this as a real issue. You have some attorneys that simply were not following the rules and were not educating themselves on the rules. So we asked the Florida Board of the Bar Governors, the Board of Governors of the Florida Bar, to look at the issue to see if we needed some specific disciplinary process to deal with this issue. They basically came back with that, you know, to us and said, you know, this is an ordinary disciplinary issue with lawyers. So as opposing counsel, if a lawyer does not file something, you know, do you want to file a grievance against them? Do you want to bring it to the attention of the judge that's assigned to the case? That's probably the easier thing to do, to try to do some education as opposed to going to the disciplinary route.
We get that a lot with defense counsel filing discovery without it being redacted. We will email them and contact them, and their staff are like, huh? They are totally clueless, and they will do it over and over again. And particularly insurance defense counsel staff do that all the time.
Oh, don't make such a generalization.
Thank you, Judge.
Thank you.
I got him.
Doing civil trial work, I have a similar problem with the criminal defense lawyers who have a pressing need to take a look at arrest and booking reports. Sometimes when somebody calls me, they've been served with a summons and there's like 2 days left for an answer to be filed. I understand I could do a viewable on request. I just wanted to make sure if I had a pressing need like that, that I could come down in person to the courthouse and I could get the documents that way. So I could either get them in person, I could do the VOR, or eventually they may wind up getting scanned through and redacted, and then they'll be public for everyone.
Correct.
Thanks so much for your answer.
Yes, sir.
Homer Bliss, I do family law, so to put it in context.
You got a whole extra set of rules on you.
Yeah, I bet you do. Since '95, I've represented a gentleman, and I've been the only attorney of record. Last week, he came in. He wants to modify, and so I tried to pull it up, and I didn't have access. So, clever me, I filed a notice of appearance and got a very pleasant call from your office saying I had to pay a $50 reopen fee. I've been the attorney of record since day one.
Okay. If you are the attorney of record on a case, now, where's Jill and Gerald? Because
it ends after.
Yeah.
However, a party, you can also direct a party to request access to that case as well. Yeah, well, and that's what I was going to ask.
Hold on, I want to reiterate that answer. Okay, so when you are the attorney of record on a case, after that trial ends, after the final judgment has been issued, you have how many days?
It's at 30. 30? Okay. 30 days.
You have 30 days after that, and then you become just a registered user. Okay?
But I got to pay $50 to get my file?
Well,
or you can have your party on the case register and include the case number that they are party on. When the registration is looked at, they will also grant that they will now have party access to the case, which increases their security level. In most cases, relatively close to what the attorney gets.
Or you can come down to the courthouse and review it.
How quickly
Does that party access kick in?
Right now, with the backlog of registrations, it's taking longer than it will once things start to settle down. Once we have all the attorneys in and registered, parties will slowly start coming in. So we're shooting.
Are you reactivating the case, Mr. Bliss, or are you just trying to view?
Yes, I'm just trying to view.
Okay.
At some point.
I want to make sure that I understand. There can be multiple attorneys of record, correct?
On criminal cases right now, yes.
Okay.
Civil as well? Yes.
In our firm, we put multiple names on the signature line. All of those attorneys, or both of those attorneys, are not always becoming attorney of access. What is the easiest way for us to make that happen?
We are not looking at the signature line to say who's the attorney of record.
We put our firm. The client is hiring the firm, and I guess that's sort of my next question is, are there any plans for, these are the attorney at this firm has filed a notice of appearance, and so then all of these attorneys at this firm, because we're a small firm, and I understand that this doesn't apply to everyone.
I know where you're going with it. I gotcha. We have had those discussions. We are looking at opportunities within the matrix for that. In the meantime, there's delegation. So I know that I didn't do it.
I understand they hire the firm, but an attorney has to sign the document on behalf of the firm. And for now, you would just say, okay, it's me, and I delegate her, him, and him.
So we need to go into each, the most practical way to do this is to go into each and every case and delegate.
Well,
when you want to view online.
It's
based on your access.
Okay.
So that's a great point of clarification. Okay. When you delegate access, you are not only delegating access to one case. You are delegating your access to your records. So your access level is being delegated. Okay.
That makes more sense.
There are some firms who are people can figure out how to circumvent the system before we can figure out how to get it in place. But there are some firms who have one attorney who files, and they are the one who signs, and they delegate that person's access.
Okay. And then one other quick question. Moving forward, it seems like the easiest way is to sort of redact these things and make sure they're redacted as they're being filed. Is there plans to do that?
That is being done.
Okay.
That is being done. When you e-file a document, it comes into our office, it goes in an e-filing queue into the direct department that it is associated with. That department then it runs through auto redact, they review it, and then it's available.
I guess I criminal law. So why are these arrest and booking reports, which are the main thing that we need, if they're being redacted as they're filed, why can I not get access to them?
How many arrest and booking reports do we get a day? And how many of those they're being auto-redacted, but as we talked about, JSO is not reliably filling those out. Not every officer has been retrained to fill them out correctly. So if a confession in that case is released, it can ruin your case. And then our office is not indemnified, and we end up before a judge in a lawsuit.
So right now, only the auto-redact is being run as it's filed, and then when we push view on request, it's going through the second process of an individual.
We are working through the process of making it better. Okay, in felony right now, they've finally gotten it down to 1,000 documents that are waiting. So, and those are part of that. That number has not gotten below 950 yet, because I watch it all the time. But we are working as much as we can. I know Judge Munyon wants to.
She's the person that asked questions already.
Oh, okay.
So she can address it if she wants to. You want to address that issue?
I just wanted to correct something I said earlier, and unfortunately the woman that asked the question just left. Records available at the clerk's office. There was a indication that you don't have to give any writing to request a public record. Oh, there you are. Yeah, you don't have to request a public record at the clerk's office in writing. Actually, Rule 2.420M requires that all judicial branch records that are requested be requested in writing. So there is a specific rule of judicial administration that addresses that issue at the clerk's office, not just online.
All right, thank you, Judge. This lady right here.
We'll share. We'll share.
I work for one of the anomaly agencies, and we're still having issues with our attorneys. You know, we've got mental health, dependency.
Which agency?
RCC.
Okay.
Who's the best contact at the clerk's office? I kind of inherited the core responsibilities when our prior administrator left. It's like, oh yeah, all you got to do is go in and do whatever. Well, clearly there's a lot more to it than what I was told when I got this a couple of months ago. Okay. Rather than bore everybody with the details of all the issues we're having, who's the best person in your office that I can talk to get some guidance on, number one, what do we need to do? How do we resolve the problems? I have attorneys that are the attorney of record on dependency and mental health cases that still don't have access to their files, which is obviously after weeks becoming a huge issue.
So attorney of record, that should be able to be rectified.
Okay.
If it's not, I know the agency as a whole, there's an issue as to where to place you in the matrix and who grants that access. That's one of the issues we want to take to the Access Governance Board next week. Okay. So we need to address it further. Right now, you can keep those questions coming to the core help desk, and we'll be glad to work with you directly on that.
Okay, just go through that one.
Yes, ma'am.
Okay. Now, what kind of turnaround time are you looking at on some of these questions? I know I've posed questions before, and I'm still waiting on responses, which, as you know, attorneys aren't all that patient for an indefinite. We're working on it.
Right now, we're just in the backlog. But not only are there 5,000 BOR requests out there are hundreds of emails that we're still trying to wait through. There are new registrations that are coming in, and that's a very small staff. It's a portion of the IT staff that's doing that. So I just tell you, I only have some of the staff available to do it.
Unfortunately, attorneys don't like that explanation. I'm sorry.
Well, we're processing as quickly as we possibly can. I mean, that is the best that we can say. My leaders get hammered every day. Why are there this many in your queue? Why have you not cleaned out your queue? Why are there this many? E-filing. You do not let your e-filing queue get backed up because you're focusing on BOR. E-filing is just as important. We can't say it's more important. We can't say it's less important. It is equally as important. You have to maintain both queues, so their workload has doubled in addition to now the emails that the IT staff is now getting as a result of it. So we are working as quickly as we possibly can.
And the question I know that I'm going to get as soon as I get back to the office, I have attorneys that don't have access to their cases. What do I need to tell them to do?
They are, but there's another.
That was my question.
Oh.
Yeah.
Okay, Gerald. You need to get a mic, please.
Yeah, that was my question.
So the question,
we have a lot of cases that we're attorney of record of. First off, I just want to say thank you very much for implementing this, and so we don't lose our electronic access, because I deal with hundreds and hundreds of cases out of all different kinds of counties, and this is still the fastest and easiest way to get access, because we don't have to go to the courthouse, we don't have to pay for the records, you know, so just thank you for that. And I know I'm frustrated just like everybody else. However, we are attorney of record on many of cases. We don't have access to them. I forgot, I was in the overflow area. Do we email? Do we call? What is the easiest way?
This is the best thing to do. If you will, you can do one of two things. You can call the department that the case is filed in, give them the case number and they'll fix it. Or you can email a list of your case numbers to that email address and we'll go in and fix them.
Okay.
Calling's probably quicker.
Thank you.
Did you have a question, sir?
As a mediator, where would I be on the matrix?
That's actually one of our questions as well.
That's one of those one-offs.
Have you been appointed as mediator in the case?
Well, yes and no. What about on those where I have not yet been appointed, and then what happens once an order appointing is entered?
Well, I just asked the question. I don't know the answer to that, but no, and the only reason I think that's a big distinction. If you have been appointed by the court to be the mediator,
okay,
I don't know. Maybe Judge Munyon would know, but I think those are all issues that we're wrestling with, and that's why events like this are good, because you ask questions that maybe we didn't think of.
Because I don't think I meet the requirements of being an attorney of record.
No, you would not.
But I still need the access to the file.
Right. Well, and again, once these things have been redacted, and once they've gone through the redaction software and the eyes have been on them, it's public. You could get it, your neighbor can pull it up. But I understand the difficulty right now.
The other question I have is, I have one case where, before you turn the switch on, and I was going through and looking, an attorney had filed the notice of confidential information, and they claimed the entire financial affidavit was confidential, so I cannot view it online at all. Any suggestion on how I can, can you just file notice of confidential information on everything and just block everything?
Well, when there's a conflict in that, it has to be risen to the level of the judge, and the judge has to say this is not, the clerk is a ministerial office. So the clerk is not here. We do not provide legal advice. We do not make legal judgments. We are, if you file a notice of confidentiality as an attorney, we look to see if it applies to 2420 or statute, and if it does not, we cannot simply deny it. The judge has to make that determination as to whether it will be confidential or not.
Okay, I understand. It's just, I don't want to have to file a motion. I have a hearing before a judge to get a financial affidavit that I might need to prepare for a mediation conference.
If a notice of confidentiality has been filed to protect that document, the clerk's office does not have the legal authority to release it.
Okay.
And I can add one more thing. As a mediator, you can be added as a party on the case, and then through your registration, we can add you that way, and then you will have some elevated level of rights as a party.
How would I get added as a party?
Through the, if you're already a registered user, send an email to Core Help Desk, and then we can do it that way.
Go ahead.
Just want to clarify what you said. I have filed notices of appearances on my cases, so therefore I should have access to all the documents in there. And if I don't have access, I should send an email to Core Help Desk with the case name and
the case number and your bar number. Or you can call the department that you're filing the cases in, and they can go in and do it. It's a little quicker if you call. However, now my departments, some of my leaders are like, please stop saying to call my department. But yes. Okay.
Now that they've had a change in some of the counties, it's sort of changed here, that instead of making the image of our signature on the pleading, so we're supposed to do the double lines or the S in it, that's going to affect for what, 24 seconds? I've had a joint stipulation of substitution of counsel filed yesterday with my signature in it, and granted there was a substitution of counsel, I'm not upset, but I wasn't even asked to put my signature in there, and it was put in there and filed. The gentleman who was sitting next to me, the plaintiff attorney, he had defense counsel file a dismissal with his signature line in there. If it becomes an issue, and in that case I was okay, he said the case was settled, but it's still his right to do that. If it comes up where it's a legitimate issue where we didn't sign it and we don't want to file, what should we do?
I think you would file a motion with the judge who's handling that case to have that document removed from the court file. That's the only way a clerk can remove a document from the court file, is get an order from the judge and says remove that. And then the judge, the clerk, as I understand it, can remove it and pull it out of the database and nobody can see it.
And I think you should call the sheriff. But that's just me, because I think that's a forgery.
Call me right after. Okay.
Well, at a minimum.
You can, you can ask if you want. Or you can just call me directly.
I think somebody's supposed to get the supervisor to call me.
I can make them call you.
Look at the file to determine what's going on in a case. What do I do? I mean, what?
Until this system's in place, that's the only option.
Now, obviously, they need to
I wish I had better answers.
file one for 700 cases or...
You know, the part...
I tell the client to left their behind down here and get copies. They're in my office. We sit in front of the computer. There's a process that I will figure out when I get back there. They register online. How long from the time they push send to the time that you get the registration, or the clerk's office gets the registration, do they have access to their file?
Right now it's a backlog with everything else, but once we get the attorneys, the users that are already registered in the system, that volume will drop and we'll be able to turn those around within a few days. Right now it's taking more than a few days, but that will eventually alleviate itself. But that's the easiest way to do it.
On behalf of my judges, I've got to get them up. We've got a meeting with some DCA judges that happen to be here doing arguments. So I wanted, you say one more.
Let her get it. Okay.
Go.
I just have a question on the gatekeeper status. Can you give some more clarification on that? So every law office...
And kind of hold that for 2 seconds. Does anybody have anything specifically designed for Judge Munyon or for Judge Roundtree?
I wanted to say one thing, because somebody asked, I can't remember, why aren't motions, why doesn't this motion say this, do that? I can only speak for Alachua County, but I sensed it's kind of the same thing with CORE. Each clerk has their own management system, and I'm speaking way beyond my intelligence on this subject, but I've heard it enough that I understand. And each case management system has an XML dictionary that defines data elements, and the clerks have specific codes for certain documents. So in my circuit, we have an integrated case management system that has to know the data dictionary for each of my clerks' case management systems so we can pull that document up. Now, I don't know if that's what CORE is doing, but if Clay has a different case management system, so it's a very, very complicated, time-intensive process to get this done right. Why isn't a motion for summary judgment the same in every county? Right. Well, because clerks have different case management systems. Their IT people coded them differently. And if I know the definition, then I can figure it out. But you got to get down into that and do it.
And one of the things that hasn't been talked about at all here, I know when I'm from Orange County, we're a large county, and when we started exploring actually installing the judicial viewers and making sure everything was coded correctly, our clerk had 27,000 codes for documents. And that is a lot of codes to go through to determine which ones need to be VOR and which ones can have absolutely no confidential information in them. And I'm sure that with the legacy systems that all clerks have, that they've inherited some code tables that are absolutely monstrous.
Absolutely. That is absolutely a great point. It comes back to what Clerk Green was talking about in the standardization and e-filing, is the just ridiculous length of different names for the same type of documents, and just trying to bring some standardization to that. All of this is a learning process. Again, this is just a 90-day test period, 90-day pilot period. At the end of this, FCTC will evaluate, are we adhering to what we submitted in the application? Are we doing it within the confines of 1518? If so, we will have approval to continue, we will have official approval to continue moving forward. And again, this is going to be an ever-changing, living, breathing system, because as legislation changes, the matrix will change. As the matrix changes, your access will change. If the clerk, there are some discussions Judge Munyon was discussing, if the clerk is indemnified of responsibility, if you file a document without filing notice of confidentiality, the clerk does their due diligence and something goes out, I can say I would be substantially more comfortable with that process with an indemnification for the clerk But right now, my boss is the one whose face is in the paper and his name is in the paper. When a witness gets out, when a confession gets out, it is our attorneys who have to stand and defend it because it is our name, it is Ronnie Fussell's name or the clerk of the court's name that is in the paper. It is not the attorney who filed it. It is not JSO, it is not SAO, it is the clerk of the court who released the information. So we are going to do everything possible while, if that is the case, to protect the information. We did have one question back there that was it was a great question regarding VOR.
I'm not let's say I'm not an attorney of record, I'm not a party to a case, but I've requested a record in a particular case. Can it be denied? And if that request is denied, how can I appeal that?
There are very, very, very limited circumstances where a request would be denied. So with those thousands of docket codes, if something was, a glitch happens and a file should have been marked confidential and it wasn't, and you've requested it, and that brings that to our attention before it goes public. If it is marked as confidential, we will respond back, let you know that it has been rejected and why. Okay, there will be an explanation as to why if it has been rejected. Largely, that will not be the case, but in those few circumstances, there are more outside of confidential and sealed, but very, very, very limited. Yes, ma'am.
Funding is a huge issue. It's
Absolutely.
Several times. I don't understand why don't we standardize it across the state, put core in every county across the state, purchase it one time, give it to all the courts. I don't understand why we are recreating the wheel 67 times.
Well, and part of that is because prior to an electronic system, it really didn't matter what each different clerk was doing, did it? Because really you dealt with Duval, Clay, and Nassau. That was it. But with the technology, with the information age, with information changing every day, you're able to go into other counties and look at their cases. You have clients that are calling you from outside of Duval County. It is now becoming an issue. You can e-file from across the state. So there definitely is a move to that is where FCTC is coming in. They are trying to put in some standardization. However, again, I reiterate what Judge Munyon said, Judge Roundtree said, Clerk Fussell said, this is not a requirement for clerks. This is an optional service that clerks are providing. If it ever comes to the point where the legislature, the Supreme Court mandates that clerk of courts provide this, there, I assure you, will be substantial standardization to it. You know, on one hand, it would be great to see core go out across the state. However, our office built it and developed it. I don't have the staff to support 67 counties. But with that going forward, with the processes that are happening, with e-filing, it is going in that direction. But again, until it's mandated, every county, every constitutional officer has the ability to do what they will, what they can, within their budget, within their staff, etc. And budget is a huge issue. I'm sure you guys have seen in the paper, there's been a budget shortfall for the clerks across the state. And there are decisions being made to cut 5% off of last year's budget. And I mean, think about that. In Duval County, that's $847,000 that we're supposed to cut. Where do you cut that from in 3 months? Where do you cut it from? Do you cut it from staff? You cut it, and a lot of clerks have had to cut office hours. They've had to cut staff. They have staff on furloughs. We have been able to manage our budget without having to do that, thankfully. But imagine right now, if we are dealing with the VOR request, with the volume that we have, with the limited staff, with cutting office hours, we are paying our employees overtime right now to process these, to try to catch up the backlog that came from the beginning, from those first couple of weeks. We're trying to hammer that down, and we've had to authorize overtime. But with those budget constraints that are continuing to go forward, we foresee it next year as well, it is working through all of that. And again, not required by the Supreme Court, and it's an unfunded mandate. So, keep with us.
I'm looking for a little bit more information on the gatekeeper.
Okay.
Is it required for all law offices? And is there an agreement that we have to fill out? And is that online? I haven't looked, so forgive me.
There is a gatekeeper, that's the great gatekeeper. A gatekeeper agreement online. Jonathan, I know you're right there. You've had a lot of hands in this. Can you answer that question for her? I don't think that one's working. There is a gatekeeper agreement. Why can I not say that word right now? A gatekeeper agreement. Jill's going to give it a little more answer.
Right at this moment, we don't have gatekeepers for law firms. We're working on that. We got our 90-day trial period. We'll work with that. For right now, every attorney would still need to create their login with their bar number, and then they can delegate to their staff their rights.
Okay, and what happens when the gatekeeper agreement comes into play? Then do those, say, 25 attorneys or 30 attorneys in the office all need to have that gatekeeper, which you don't have?
No, you just have one person as a gatekeeper, and they would manage all the logins for their law firm. Is how it would work, but we're still kind of confused at how a law firm or attorney access gatekeeper would work, because you have to go by the bar number. So
that's one of the questions we're looking for answer for FCTC. It is not required for every law firm. That was one of your first questions. It is not something that is required by every law firm, but it's one that we're looking for further answers on. State's Attorney's Office is a great example of it. They all have the exact same access. They're all the state's attorneys, but it is by bar number. But there's one person who delegates that. They have a lot of attorneys that go in and out. So it's keeping accuracy of the records, not just by that bar number.
So there's one bar number access, and then they delegate?
No, and that's what we're working through, is your access is delegated by your bar number, but you have a gate that's working on how the system looks at the gatekeeper agreement, and that person can delegate access.
So there'll be more information.
Yes. Yes. Thank you.
Piggyback off of that, so for a single law firm, large, small, whatever, the only way to gain access is for that to go in and include the information and then delegate, set up the design and 5 people with bar number.
25 with a bar number, 25 with a bar number, 5 without.
And so when Joe Smith goes in and does that and delegates several associates as well as paralegals, when associate number 3 goes to try to access that, do they do it with their bar number or
with theirs? You can only delegate to some, that's a great question. You can only delegate to someone who is a registered user. So everyone in your office has to be a registered user. All the people have to have access. You have to be a registered user, sign the user agreement. Then you sign up with an email account. So if you wanted to delegate access to Joe Smith, you would need to know the login for Joe Smith. You would delegate your access to that. Then Joe Smith would log in with his information, but have that access. Right. Correct. Because you delegated that to him.
So when you talk about bar numbers, when we're talking about for example, so we're not doing anything with that. This is strictly
I'm going to clarify that, but it's
the person who should be registering is an attorney.
no. Everyone should register. Even the general public has to register.
So all paralegals at a large law firm.
Yes.
Also register.
Correct. That is the only way that they could be delegated access.
Need a point of clarification. On the delegation, you should really only delegate to one person. We do not have the ability at this point that if I delegate to Crystal and someone else delegates to Crystal, only one of those delegations will work. We're working through these, so you say this one delegates to these four, this one delegates to these four. You just need to be careful with that at this point. We're working through it.
So, make sure I'm understanding. I'm a paralegal, and I work with 5 lawyers. I can't be on all 5 of their delegations. Is that correct?
Is that, Josh? Confirmed. She cannot be on 5.
She's a paralegal for 5
Paralegal for 5 attorneys.
The bar numbers can be delegated to as many, you can receive as many bar numbers as you like, but the non-attorney users can only receive one.
Okay.
So that would be the paralegal.
So the attorneys could get to see all of them in the law firm if they were delegated to, but the paralegal only gets to see one right now.
Well, can I ask a point of clarification on that?
Yeah.
They don't like when I ask questions.
No.
Okay, so if, let's say, you 4 right here are attorneys, and you have delegated, she's delegated her access to the other 3, okay? So essentially, they should all have her access.
They should see each other's cases.
They would see each other's cases. Now, she delegates her access to me as her paralegal. Will I see all of their cases or only hers? See how they don't like my questions?
Is it?
We'll have to figure that one out.
We'll figure it out.
Let's test that one out and we'll get back to you.
But that'll be one of the ones that we'll put an FAQ from this meeting on the website, and so that'll be one of those questions. And with the delegation.
Address the paralegal situation.
Correct. Yes, ma'am.
I just want to make sure I'm clear on this, because as soon as I go into the meeting, I'm on this. I'm a paralegal. I work for 2 attorneys. However, I'm only going to be able to see one attorney's cases.
We're going to verify that information. That's the scenario we were just trying to work out.
I cannot receive, for me as a paralegal, I cannot receive 2 delegations from attorneys.
You can, but the question is, will you see both of them?
Both of them.
Correct.
I mean,
I'm not worried about that. I'm worried about, like, if one attorney has 15 delegations from other attorneys. My question is,
right.
I have attorney A and attorney B. They all have their own cases. They both delegate to me.
Right.
I can see both of their cases.
That's what we have to work through.
We need to verify.
We want to test it and make sure that's accurate, and we will definitely respond to that online. That is not one that we can give you a solid answer. Again, when they posed it out, I had another question. So we'll test that out and make sure we get back to you.
Go back to our firm, and they say, what do we do with our paralegals?
You say the clerk's office is going to get back to us ASAP.
But they still need to create a registration. They still need to still need to register. Go ahead and
first
do the
step.
register.
Yes.
Filers who may well be, for example, a legal assistant, would they register as well?
If they want access to CORE, if you want there is public anonymous access to CORE, where really you can essentially see primarily the dockets and the public documents. If you want to see anything other, if you want to be a registered user where you can request VOR, if you want to be a registered user where you can have access delegated to you, you must register. Yes.
Because everybody has to register, even the paralegal, you can all be, request VOR. The only difference you're going to get with an attorney is going to be the access to confidential information. You don't have to request it. You don't have to request, the information that you want. If you're a paralegal and you're in a firm, you're going through the VOR and everything. Everybody's going to have access in there already. So it's, having a delegation doesn't say that you don't have to do it, but then it's open to everybody who doesn't have a delegation.
And what about firms, and I'm not, that attorney says, here's my access to the users?
If I'm not mistaken, that's addressed in the user agreement, that you will not do that. That would be frowned upon in this establishment. Yes, they all need to register. Do we know that it happens? Yes. Have we also seen examples where an attorney gave access to their girlfriend and then they broke up and now the girlfriend is going into their cases? Yes. That has been an example in the 2 years since I've been here. Any more?
I have a ton of their individualized.
Hang tight. I'm going to give you that too, just in case. We want one of those too? Let me just make those rain. Okay, anyone else? Yes, ma'am.
So it's me and my attorney, that's it. I'm paralegal, he's the attorney.
Hey.
Registers, then I've got to register too.
Correct.
And I'll get my own.
And he'll delegate access to you. You're golden.
Okay, all right. And
man, that's easy.
This is, so many of these questions didn't relate to family law, but like you said, there's a whole other issue. You come in, you call me, you want to come in next week for a consultation. We want to pull up your final judgment. We didn't represent you before.
Right.
Can we do the VOR?
You can do a VOR. I will say right now there are a lot of requests in family law.
Right.
So you could do a VOR or you could come down, either way.
So once everything gets smoothed out, you're coming in next week, we could do a VOR, and that makes it...
then you would be able to see it. After it's been redacted, you would be able to see it. Yes, ma'am.
And does that make it public forever, or does just...
Unless a legislation change happens. So the example I gave of the redactions earlier, there's going to be a legislation change that happens October 1st, clearly. And so October 1st, we will have to reset VOR to be sure that names are redacted, if it has been requested. So...
Also, if the document has been changed, it goes back to VOR status. Like if something was added to the back of the document later, after it had been requested and redacted, it'll go back to VOR.
Yeah, great point.
But if you're coming in next week, so I've got it and I'm viewing it, and then you go see another attorney, that attorney's going to be able to log on and see it.
Correct.
That's going to already be there.
That's correct.
All right.
Anyone else? All right. Thank you guys for hanging around.